Welcome to FFRF's Ask an Atheist program. I'm Annie Laurie Gaylor, co-president of the Freedom from Religion Foundation, which produces this weekly show.
And I'm Liz Cavell, an attorney at the Freedom from Religion Foundation. And we're going to talk today with two special guests about the threatened status of abortion rights, including a pending Supreme Court case out of Mississippi. It's about a Mississippi law that bans abortion care after the 15th week of pregnancy. So joining us remotely today is Barbara Alvarez. She's FFRF's Ann Nicole Gaylor reproductive rights intern. Barbara's been monitoring legislation. She's written many blogs and editorials for the Freedom from Religion Foundation, documenting that abortion rights really are under siege right now. So welcome to Ask an Atheist, Barbara.
Thank you so much for having me, Annie Laurie and Liz. It's wonderful to be back on the show and talk about this important issue.
And we're delighted to introduce our second guest, Chicago School of Law professor Jeffrey R. Stone. Jeff Stone served as a law clerk to Supreme Court Justice William Brennan the year that Roe v. Wade came down. He's an expert in constitutional law. His many books include Sex and the Constitution, Sex, Religion, and Law, From America's Origins to the 21st Century. Jeff's joining us from his summer retreat in Michigan. Thank you so much, Professor Stone.
Thank you for having me. I'm delighted to be here.
And you can join in our show by making comments and or asking questions for our guests via Facebook here in the comments below, or you can email askanatheist@ffrf.org.
And before we talk about the upcoming Supreme Court case and the history of threats to Roe versus Wade, Barbara, can you give us an overview of the current status of legislative assaults against abortion rights? What are we up against?
Absolutely. We're up against a lot. According to the Guttmacher Institute, 2021 has been the most destructive anti-abortion state legislative session that we've ever had. We are only halfway through the year, and already we've seen 561 abortion restrictions and 165 abortion bans introduced across 47 states. Of those bills that have been introduced, 90 have been enacted across 16 states, including 10 abortion bans. And these restrictions and bans, they run the gamut of medically unnecessary restrictions to abortion facilities and providers. And they also include restrictions on who can perform care, misinformation about abortion reversals, and they can require women to make several visits to clinics or just outright deny them healthcare coverage. There's also this really worrisome trend that we're seeing about anti-abortion ordinances. Most recently in Lubbock, Texas, they passed an anti-abortion city bill, which basically is driving Planned Parenthood out of the city of Lubbock, Texas, and Lebanon, Ohio has done the exact same thing. So this means that women will have to travel hours and hours to get to the nearest clinic. In Lubbock, Texas, they are driving the Planned Parenthood out of the city. However, Planned Parenthood is fighting back. And that means that women are going to have to travel 5.5 hours to get to the nearest clinic. In total, there have been roughly 30 cities across the United States that have passed these ordinances. They're largely in Texas, Nebraska, and Ohio. So all of this is really disturbing to the state of women's health care in this country.
And briefly, Barbara, what's the role of religious lobbies in all of this, and why do you consider abortion rights a secular issue?
Well, abortion rights is absolutely a secular issue. According to the latest research that's been done by Pew Research Center, around 6 in 10 U.S. adults say that abortion should be legal in all or most cases. In fact, religiously unaffiliated Americans overwhelmingly support the legalization of abortion. 82% say that abortion should be legal in all or most cases. This is in contrast to 77% of white evangelicals who support banning abortion. And churches are instrumental in passing these anti-abortion legislations. For example, in Lubbock, Texas, the churches played a very key role in passing that anti-abortion ordinance and organizing on what is a medical issue, not a religious issue. In addition to that, there's a lot of money that's going into anti-abortion restrictions. So the National Christian Charitable Foundation, which is the nation's sixth largest charity, they fight against abortion rights, and it's supported by Christian nationalist megadonors like our former education secretary, Betsy DeVos's Family Foundation, and the billionaire owner of Chick-fil-A and Hobby Lobby. And the foundation has granted more than $6.5 million to Alliance Defending Freedom, which is a Christian extremist legal interest group. And that organization fights against abortion as well as LGBTQ rights. And they fund many of these cases. So it's a lot of money.
Yeah, that's astonishing.
Thanks, Barbara. So Professor Stone, we're going to turn to you, but before we talk about Dobbs v. Jackson Women's Health, which is the case the Supreme Court's going to be hearing out of Mississippi, can you tell us a little bit what it was like clerking for Justice Brennan, especially at the time when Roe versus Wade came down?
Well, clerking for Justice Brennan was a delight. He was a truly remarkable individual and a wonderful justice. In terms of Roe, at that time, the justices were struggling not so much with the outcome in the case, but with what should be the correct rationale. And the year before the court decided Roe, they heard the case, and they had voted. There were only 7 justices at that time, because Justices Powell and Rehnquist had not yet been on the court. And the justices were divided about exactly what the rationale should be. And Justice Harry Blackmun, who was assigned the responsibility for writing the opinion in Roe by Chief Justice Warren Burger, was inclined to write an opinion that would have had no significant impact on women's rights. That is, at that time, what he was concerned about was the fact that the anti-abortion law from Texas allowed a doctor to perform an abortion in circumstances in which he knew it was necessary to preserve the health or life of the woman. And Blackmun was concerned that, what does it mean to say necessary? How does a doctor know whether an abortion is necessary to save the health or life of the woman? That's ambiguous, and therefore the statute might be held to violate due process of the doctor's rights because it's simply unclear. And at the end of that term, the justices decided to re-argue the case and to consider it further, and then to give Justices Powell and Rehnquist an opportunity to participate. And so they re-argued the case the following fall. And over that summer, Justice Harry Blackmun, who had been on the board of the Mayo Clinic, went up there during the summer and did research about abortion, in particular about the history of abortion through Western civilization and in the United States, and also about the realities of the life for women in having to deal with illegal abortions. And that was still something that most people knew virtually nothing about, because abortion was illegal and women were therefore reluctant to say much about that. And so Blackmun came back to the court and explained to the other justices what the reality of the history was about abortion. And I'm happy to come back to that later. But it was basically that abortion was perfectly legal throughout Western civilization and in the United States at the time the Constitution was adopted, and until the late 19th century. And women could get abortions legally, and there was no significant restraint on them. That only changed for religious reasons in the late 19th century. And that was a surprise to most people who didn't know that abortion in the late 18th century, a woman could simply go out and get an abortion from a midwife or whatever, and it was completely legal. Most people thought abortion had always been illegal, which wasn't true. And then the second factor is getting a full appreciation of the reality, the horrible reality of the experience that women encountered in seeking out illegal abortions prior to Roe. And these were either individual women who used um, uh, uh,
Coat hangers.
individual devices
Yeah.
to abort themselves, like coat hangers, for example. Or women had to find somebody who could perform an abortion, so they'd ask taxi drivers or elevator operators, I have a friend who's pregnant and doesn't know if she wants to continue to be pregnant. Do you happen to know anyone who I could recommend to her? And they would get a name and a phone number, and they would call, and they would be told, meet us on the corner of 63rd and Elm Street at 2 o'clock in the morning, face northwest, and we'll take care of you. And they would go there not having any idea who these people were. They would come up from behind her, put a blindfold, push her in the back seat of a car, and then take her to some undisclosed location. Could be anything from a hotel room to an office to literally a back alley. And someone who she had no idea who it was, because it was illegal, would perform an abortion. And if things went okay, she'd be pushed back in the car and dropped off where they'd picked her up, being blindfolded the entire time. So the justices learned about that. And this, for them, magnified dramatically the importance of this right and the extraordinary impact the criminalization of abortion had upon the lives and health of women. So during that year, when I was a law clerk to Justice Brennan, those were two critical factors, I think, in encouraging the justices to go full hog and to basically say there is, in fact, a constitutional right of women to control their own reproductive realities, and to hand down the decision that they did in Roe v. Wade. And it was a 7-2 decision. 3 of Nixon's 4 appointees, Berger, Blackmun, and Powell, voted that there was a right to abortion. 5 of the 6 Republican appointed justices voted to support a right of abortion. And the justices were really quite confident that this was the right decision. And a lot of deliberation went into how to write the opinion. But the justices, at least 7 of them, were quite confident, including 5 Republican appointed justices, were quite confident that this was indeed the right approach.
So, Professor Stone, what's now at stake with the case that the Supreme Court is hearing this fall called Dobbs versus Jackson Women's Clinic or Health?
So in Roe, Justice Blackmun, the question was, how do you allow the state, in what circumstances can the state regulate or prohibit abortion? And in his opinion for Roe, Justice Blackmun, joined by 6 other justices in the majority, basically divided that issue into 3 parts. He said essentially in the first trimester of pregnancy, the first 3 months, the state basically cannot regulate abortion. That abortion is a reasonably safe procedure, and it doesn't require any greater government intrusion or regulation than getting your tonsils out, for example. In the second trimester, Blackmun recognized that it was quite realistic that in some circumstances there would be complications, and there would be legitimate health reasons for the state to intervene, as there would be if you wanted to have heart surgery, for example, where the state can put in place regulations about who can do it and in what circumstances. And then in the third trimester, Blackmun concluded that in the third trimester, the fetus becomes viable and therefore can survive outside of the woman. And at that point, he concluded the state's interest in choosing to preserve the life of the fetus was sufficiently important to allow the state to prohibit abortions in that circumstance, unless the abortion was necessary to protect the health or life of the woman. And the notion there was that the woman could end the pregnancy, and yet the fetus could still survive. So that's how the court in Roe articulated its approach to the question. And fundamental to it was its judgment that the right of a woman to control her own reproductive freedom and the freedom to decide whether or not she wanted to be pregnant and have a child was a fundamental interest protected by the Due Process Clause, and the state could not regulate it unless it had a compelling government interest. In 1992, to bring us closer to the present, the makeup of the court had changed dramatically. By 1992, 8 of the 9 justices had been appointed by Republican presidents. And the Casey case came before the Supreme Court, and virtually everyone expected the court to overrule Roe v. Wade at that time. And to the surprise of virtually everyone, Justices Kennedy, O'Connor, and Souter, all appointed by Republican justices, decided that it would be inappropriate to overrule Roe v. Wade, that it was a fundamental precedent that was based on a reasonable understanding of our Constitution, that it had a fundamental impact upon the lives and health and experiences of women, and that therefore Roe should not be overruled. And therefore, in a 5-4 decision, they were joined by Justices Blackmun, who was still on the court, and Justices John Paul Stevens. So all 5 of them had been appointed by Republican presidents, interestingly. They basically re-examined Roe and said that the trimester approach that I described earlier was not necessarily ideal, and that a woman's right to have an abortion could not be prohibited prior to viability, period. But in the period, in the 6 months or so before that, the state could regulate abortion as long as it did not pose an undue burden on the right of the woman. So it gave the state somewhat greater flexibility to engage in things like giving a woman warnings of the potential consequences of having an abortion, or potentially requiring, informing the husband that a wife was going to have an abortion. But relatively modest restrictions. And that's been the state of the law since Casey. And now, we'll come back to Dobbs, but what's happened is states have enacted far more aggressive restrictions on abortion than anyone would have really imagined back in 1992. Most of them have been under the guise of protecting the health of the woman. So, for example, many states have said that a woman cannot obtain an abortion from a facility that does not have the authority to admit its patients to a hospital. You have to have admitting privileges. And that the court, in a 5-4 decision a couple of years ago, Hellerstedt, held was unconstitutional, saying that that was an undue burden on the right of women to exercise their fundamental right, that this notion of having admitting privileges really assumed a degree of seriousness in the health aspect of abortion that was completely unrealistic. And that was not a requirement for all sorts of other medical activities that were potentially far more dangerous than abortion. And there's a whole other series of restrictions like those, where states attempting to manipulate the undue burden standard were basically putting in place restrictions on abortion in the guise of protecting the health of the woman that were designed to make abortion ever more difficult. And the consequence of these has been essentially to reduce profoundly in those states the number of facilities that can perform legal abortions. So Mississippi, for example, now has only one facility that can legally perform abortions in the state. Whereas at the time of Casey, it had many, many more than that, which now makes it far more difficult for women to get access to that facility. So that's been the evolution of this state of the law. The court has held those laws thus far unconstitutional, but now we have a makeup in the court that is everyone believes, far more committed to an approach to constitutional interpretation and to religious views and to abortion than we've ever had since Roe was decided.
So tell us, what is that law that is being appealed, the Mississippi ban? What would it do?
So what the Mississippi law does is to say that a woman cannot get an abortion in the state of Mississippi after 15 months of pregnancy, unless it is necessary to save the life of the woman. And this is in direct defiance of Roe v. Wade and Casey, which held that the state cannot prohibit abortion until viability of the fetus, which today is probably around 24 or 25 weeks, not 15 weeks. So this law is in absolute direct defiance of Roe and Casey. It basically says we can prohibit abortion at 15 weeks flat out, except for the one case of the life of the woman. But even if the woman was raped, even if there was incest, no right to abortion after 15 weeks. So what that does is basically erase the viability standard that the court had embraced in Roe and reaffirmed in Casey, that gave a woman a right to abortion except when the state regulation was not an undue burden on that right prior to viability. Now it says at 15 weeks, we don't give a damn about viability. You can no longer have an abortion after that period. So it's a direct defiance of existing Supreme Court precedents. And clearly the idea, at the very least, is to get the court to overrule that critical aspect of Roe and Casey and all of the cases that have been decided since then.
And Professor Stone, maybe we should explain that the abortion clinic appealing this ban had been winning at the appeals level. So the fact that the Supreme Court took this case is a very bad sign, is it not?
Yeah, every court that has addressed the question has said this is clearly unconstitutional under existing Supreme Court law. And it is. There's no question about that. This is direct defiance of Roe and Casey and subsequent decisions. So lower courts, who have an obligation to apply the Supreme Court precedents, obviously have to uphold those precedents and therefore strike down the law. So in agreeing to hear the case, the justices at the very least have indicated that they are willing to reconsider both Roe and Casey insofar as their assurance that women have a right to abortion.
So it was shocking, was it not, that they took this case?
Well, it's not shocking if you understand that they are open to overruling that part of Roe and Casey. It's shocking if you assume they're just going to apply the precedents. That's why the lower courts found it easy, because the precedents are unambiguous. But from the justices' standpoint, they would say there are times when the Supreme Court overrules its own precedents, and a number of justices have argued in the past that Roe should be overruled. And now we have 5 or 6 justices who are likely to embrace that point of view. So it's shocking, not in the sense that, given the makeup of the current court, that they would think that Roe should be overruled, but it's clear that they're prepared to re-examine the precedent in a way that lower courts would not appropriately be able to do.
So, Professor Stone, I just am wondering, you talked about the case not 2 years ago that the Supreme Court struck down in Hellerstedt a admitting privileges requirement out of Texas, a Texas trap law. So we know nothing has changed since then except for markedly the makeup of the Supreme Court, and you're saying that's critical here, but what can we expect, especially given the role of Justice Roberts, although I know the numbers aren't there anymore, what can we expect in terms of just the court grappling with Hellerstedt, which was not very long ago, precedent of the court, and just this bold defiance of Roe precedent this coming case? What can we expect from the court who just decided and upheld this long line of cases in Hellerstedt?
Well, Roberts was the only one of the justices who people today think might be open to upholding the Mississippi law, who voted in the most recent decision to strike down the challenge law. In prior cases, Roberts had dissented from the same basic decision. So the court has not, the conservative justices have not adhered to precedent. Even in this most recent decision, Roberts did vote to strike down the same kind of law, prohibiting abortion in those circumstances, that is by a facility that didn't have admitting privileges. But he wrote an opinion that was very crafty in terms of saying that, well, this law is directly inconsistent with that one, but we should not address that issue right now. But now with Amy Coney Barrett on the court, replacing Ruth Bader Ginsburg, I think it's pretty certain, one can say, that there are 6 justices on the court today who emphatically, unequivocally believe that Roe v. Wade and Casey were wrongly decided. And the question for them is, to what extent do they adhere to or honor precedent that they believe was completely illegitimate and they would never have signed on to had they been on the court at the time. And I don't have any doubt that if they felt they could do this without causing too much criticism of the court as an institution, that they will do that. Now, invalidating, or I should say, upholding this statute is not necessarily invalidating and overturning all of Roe or Casey. It's simply eliminating the viability rule. It still allows women to have abortions in the first 15 weeks. So what the justices could say is that we are overruling the viability rule of Roe and Casey, but we are leaving in place, at least for the moment, the constitutional right of women to have an abortion in the first 15 weeks. And whether that will remain in place, we'll see later. So that would be a sort of a halfway, quote unquote, way for the court to purport to be respecting precedent to some degree, to a significant degree, because the vast majority of abortions, in fact, take place in the first 15 weeks. So the number of abortions, legal abortions, that would be prohibited by this is a relatively small percentage of all of the abortions that are legal in the United States today. So they can say, we can do this. Now, the question is, why is 15 weeks okay? I mean, in Roe and Casey, the court talked about viability as being a critical moment because the fetus could be removed from the woman and could survive. And so you could, quote, have it both ways. But 15 weeks is not that. You're not preserving the life of the fetus. And you're just basically saying to the woman, you can't have an abortion, period, after 15 weeks. So one of the puzzles is, what's the rationale for the 15-week rule? And I don't actually know how I would articulate, if I were arguing the case for Mississippi, I don't know how I would articulate why 15 weeks is magical. Viability, the court concluded, was, quote, magical because of the particular characteristic of it. But there's nothing about 15 weeks that satisfies that.
Before we move on, Jeff, you knew Ruth Bader Ginsburg, correct?
Yes.
So
yes,
it's very sad to see what's happened since her death.
Yes, I mean, Ruth was deeply committed to Roe. She did think, frankly, that the court went too far in Roe. Ruth said on a number of occasions that the court should have taken the issue of abortion more gradually and decided each case much more based on the facts presented in each case. And that by deciding it all at one time, the way the court did, they inflamed the opposition to Roe in a way that has led to the opposition that now, of course, exists. And I strongly, for what it's worth, disagree with Ruth about that judgment for two reasons. First, I think it fails to understand how critical the justices at the time of Roe came to understand the right to abortion was to the lives of 1 million women a year who were having illegal abortions, and what those illegal abortions involved, as I described earlier. They were absolutely horrible, and they caused hundreds of deaths a year and many thousands of serious injuries to women, because these were abortions not performed necessarily by real doctors, but by barbers and by elevator operators who had no real training to do this, or by boyfriends, for that matter. And when the justices came to understand this, they came to the view this is utterly intolerable in a free and open society, that we should subject women to this experience is utterly inconsistent with the fundamental values of our nation. And to have said, we're going to take 20 years to work this out incrementally,
Yes.
was something the justices, including conservative justices like Warren Burger and Lewis Powell and Harry Blackmun and so on, said we can't do that. That would be a complete betrayal of our responsibility to protect liberty and freedom and safety in our country today.
Yep, I'm with you, and not with Ruth Bader Ginsburg on that one. And you know, Linda
Yes.
Greenhouse, who's covered the Supreme Court for the New York Times for so many years, she has a new book coming out on this whole thing. I know she disagrees with Ruth on that issue too, but it'll be fascinating to see that book coming out this fall.
Yes, I look forward to it.
Well, there's so much to worry about in the courts, especially, and in the states. But Barbara, back to you. Aren't there some promising bills in Congress right now to protect the right to abortion at the federal level?
There are some important and promising bills that require our attention and our secular voices. So the first thing that I'd like to do is I'd like to do a shout out to some positive state bills. As the Guttmacher Institute indicated, this has been the worst year for anti-abortion state legislation. However, there have been some positive state bills. In February, the governor of New Mexico approved a measure that repeals the state's pre-Roe v. Wade abortion restrictions. A lot of people don't know, but there are many states, including FFRF's home state of Wisconsin, that still have abortion restrictions on the book that are called trigger laws, and they would go into effect if Roe v. Wade ever falls. And so Governor Grisham of New Mexico approved a measure that repeals their pre-Roe v. Wade abortion restrictions. In April, Governor Inslee of Washington signed a measure that requires student health plans to cover abortion care as well. So that's a really important step. In March, Governor Ralph Northam of Virginia signed a measure that eliminates the state's ban on abortion coverage in health insurance plans that are sold on the state's insurance exchange. A lot of insurance plans don't cover abortion, especially public, federally funded insurance plans. So this is a really important step to make sure that abortion care is accessible, not just legal. And then in May, Governor of Colorado signed legislation ensuring that public funds, including Medicaid, pay for abortion services. Previously, the public funds could only be used to pay for abortion in cases of life endangerment, rape, or incest. And so this law took effect upon signing, and that's really positive as well to making abortion care more equitable. However, this is still a patchwork of abortion rights in the United States. We have some states where abortion is becoming more and more restricted, and then some states where we're seeing some positive bills. And that means that we need federal legislation. And thankfully, there is some potential. And I'd like to highlight that. The first thing I want to point out is that President Biden didn't include the Hyde Amendment in the appropriations budget, which is a really big step. It's been there for almost 50 years. And what this does is it's a religiously inspired amendment by Henry J. Hyde, a representative from Illinois, to take away abortion funding for federal health insurance plans. And so the fact that President Biden didn't include this in the appropriations budget is really important. And it prompted a lot of condemnation from Catholic bishops who are currently debating whether or not President Biden is able to get communion. The other thing that I want to point out is that the FDA is in the process of looking at liberalizing abortion medication restrictions. They should come out with a decision this fall. Right now, abortion medication, which is extremely safe, is classified as a dangerous pill, which is not the case. And that means that women have to go in person 2 times to get the abortion pill. They typically have to go for an initial meeting and then have to return 24 hours, sometimes 72 hours later to get the abortion pill. The FDA is looking at making the abortion pill available in pharmacies. The other thing that's really important is that FFRF submitted a formal comment to reverse the Domestic Gag Rule. So the Domestic Gag Rule was a decision that was made by the Trump administration, and this prevents organizations that provide abortion or abortion referrals from receiving federal family planning. And this has endangered the health care of millions of women across the country. Prior to the Trump administration's Domestic Gag Rule, organizations like Planned Parenthood have used Title X funding to serve more than 40% of their 4 million patients with reproductive care, including cancer screenings and birth control. But what the Domestic Gag Rule has done is favored public funds going to religious anti-abortion groups. And these faith-based groups typically refuse to provide factual sex education information or contraception, or even refer their patients to providers for birth control or abortion. So that's an important step that we hope is reversed soon, and we have submitted formal comment for it. The other thing that FFRF did was we submitted congressional testimony in support of the Women's Health Protection Act. And this is something that I am really excited about and passionate about, and I hope that we see this passed. The Women's Health Protection Act was reintroduced with 176 supporters in the House, 48 supporters in the Senate, which is more than any previous Congress at its introduction. And what this does is it protects abortion rights by nullifying state abortion bans. And it would effectively guarantee the right of patients to seek abortion care and for healthcare professionals to provide this care. And it would also protect patients against these medically unnecessary restrictions that we are seeing come in all the time, especially this year, including waiting periods, admitting privileges, and limitations on medication abortion. So these really create burdensome barriers to abortion access. They're not based in science, and so we have to have the Women's Health Protection Act passed. And the last thing that I want to point out is the Equal Access to Abortion Coverage in Health Insurance Act of 2021. This is called the EACH Act, and this is a really bold legislation to reverse the Hyde Amendment and any related abortion coverage restrictions. Like I said, President Biden hasn't included the Hyde Amendment in the appropriations budget, but it could certainly be reinstated in the future. And what the Equal Access to Abortion Coverage in Health Insurance would do is permanently reverse the Hyde Amendment. Currently, 34 states and the District of Columbia do not cover abortion within their state Medicaid programs, except for limited exceptions. Also, anti-abortion politicians in 26 states have enacted restrictions that interfere with abortion as a covered health insurance service. So that means that we need federal legislation to make abortion coverage in insurance plans available to women on public and private insurance plans. So those are some positive things that we are seeing up the pike, and we need to support them and make our secular voices heard.
Yeah, nice to hear the good news, Barbara. Thank you. Professor Stone, do you have anything to add before we take some questions?
First, I want to say Barbara's terrific.
Yes, she is.
One thing that's interesting in all this is that the number of abortions in the United States has declined from roughly 1.2 million to 650,000 since Roe v. Wade. And a major reason for that is changes in contraception, which have reduced dramatically the number of unplanned or unwanted pregnancies. And the reduction in abortions has been very much predominantly in the middle and upper class women who have access to good modern methods of contraception. And one of the ways to substantially reduce the need for abortion would be to make the same quality of contraception available to poor women as is available to middle and upper class women. And there was a study done by the Guttmacher Institute a couple of years ago, I think I have this number right, which predicted that if that were to take place, the number of abortions in the United States would decline from something like 600,000 to 60,000, just by reducing the need for abortion. And it's just amazing to me that we haven't done that. Both people who are pro-abortion and people who are anti-abortion could simply eliminate much of the need, not all of it, but much of the need for abortion by simply providing first-rate contraception available to the vast majority of women who find themselves needing abortions today.
But it's so interesting that anti-abortion people usually don't care about contraception. I mean, they're often anti-contraception too. It's a real ironic twist there.
Right, and also revelatory in terms of the religious basis for a lot of these objections.
Right.
Because they go hand in hand. Well, that actually leads into one of the questions that was posted pretty handily. So we'll see if anybody has any thoughts. Are there any people, by which I think Tessa Caston asks this, by which I think they mean legislators or leaders who are actually trying to pass anti-abortion legislation, but also proposing bills to make birth control more affordable or create broader sex education programs. Do we have any kind of role models that anybody knows about in that vein who are anti-abortion but trying to expand contraception and sex education?
I'm not aware of that.
Nobody comes to mind.
That was part of the criticism I was just making.
Right.
Right.
Yeah, I've written a couple pieces for Freedom from Religion about sex education, and I haven't found anybody that's anti-abortion but pro-comprehensive sex education.
Yeah, I think this really shows why this is such an intractable kind of political issue.
State, church, and political issue.
Right, and I think the religious motivation at the heart of it really is the kind of the germ there, but it's so intractable as a political issue because there's no compromising. There's no mutual goal. The goal is not just to limit abortions in this country. The goal is something deeper and more dogmatic than that.
Right. Keeping barefoot and pregnant.
Exactly.
Liz, I'd like to add to that, crisis pregnancy centers, CPCs, which are often religious Christian organizations that masquerade as health clinics. They are firmly anti-abortion, but they don't provide any information to the people that come there thinking that they're going to get comprehensive sex education about birth control, contraception, anything like that. And if you go to their websites, they often won't have any information about that, or they will say that that is not something that they do. And they are taking tax dollars away from organizations like Planned Parenthood that provide abortion, but also provide education about pregnancy prevention.
Which is why it's critical to repeal that domestic gag rule that is penalizing Planned Parenthood. And here we are, public funding going to these religion-based misinformation centers, propaganda centers, to discourage women from practicing their rights under Roe versus Wade.
I want to add a thought that when laws first came into effect in the United States, prohibiting both contraception and abortion, the rationale for those was almost entirely religious. And the arguments in favor of those laws prohibiting contraception as well as abortion, contraception was prohibited in all of the states in the same way abortion was by the late 19th century. That the argument was entirely grounded in religion, but the other argument about it was about women, and it was basically based on the concern on the part of men that if women were able to have sex and get away with it, either by using contraception or by having abortions, that would enable them to be unfaithful. And one of the arguments about prohibiting both contraception and abortion was to keep women in their place. And the phrase that was used was basically, if you don't want to get pregnant, don't have sex. Simple as that.
And so this was under Comstock, correct? And
exactly.
Contraceptions were called indecent articles, and in fact, we had an indecent article. Wisconsin was the last state in the union to get rid of one of these indecent article laws that prohibited contraception for unmarried people. And that came through the courts. That did not come through the Wisconsin legislature. It probably would still be illegal if we were waiting for the legislature to do something right there.
Yeah, there were states that still had laws against even married couples having access to contraception until the Supreme Court's decision in the Griswold case in 1965, which held that you could not prohibit married people from having access to contraception.
There's a couple more questions, but we're running a little late, so I'm just going to ask one more because Professor Stone touched on this a little earlier, and I think it's interesting, so it gives an opportunity to kind of expound a little. So Taylor S. from Facebook asks, has there ever not been an attack on abortion rights? In other words, has there ever been a time when there wasn't just this totally hot, controversial, anti-abortion voice in our society?
Well, basically from the time of the ancient Greeks and Romans until the late 19th century, abortion was legal and common, and it was not seen as terribly controversial. There was a sense that abortion after quickening, which is about 4.5 months, when the woman can feel the fetus for the first time, was immoral and could be prohibited, but it was almost never actually prohibited. But basically, abortion was completely legal in the United States and in all of Western culture. The Catholic Church condemned it, but it was not made illegal. So in that sense, this was just, nobody thought twice about it. If someone asked, why didn't the framers put a right of abortion in the Constitution? One possible reason is it never occurred to them that anybody would restrict this. It was just completely legal. And so that just changed, as I said, in the late 19th century. And it was based almost entirely upon religious views, which evolved particularly through evangelical Protestantism.
Yeah, well, I don't want to get us to go in too late, but
well, one more question?
I'll ask one more question. Yeah, here we go from Facebook. If Roe versus Wade is overturned, do you think more bills will be passed investigating miscarriages to make sure they aren't attempted abortions, or will there be other attempts to criminalize conduct on behalf of pregnant women? What's the worry there?
I do think that that's likely to happen, in some states. If you're prohibiting abortion, you don't want to allow people to get away with it because they're being, quote, clever. So I do think that there'd be investigations into that. And if someone claimed they had a miscarriage, there would be instances in which the authorities would investigate to satisfy themselves that it wasn't, in fact, an illegal abortion. Because remember, from the late 19th century until Roe, there were 1 million illegal abortions a year in the United States. Prohibiting abortion does not eliminate abortion. And therefore, states are going to investigate when women have miscarriages and claim that it was a miscarriage rather than abortion. That's how people were prosecuted when abortion was illegal.
And that's certainly what's going on in some South American and Central American countries that are very Catholic dominated, where abortion is illegal. We've seen terrible persecution of people who've had miscarriages or stillborns legitimately because of abortion laws. Barbara, did you have something?
Lori, I'd like to add to this. First of all, you're absolutely right. El Salvador is considered the most restrictive abortion country in the world, and they regularly jail women for miscarriages. But something very scary that we are seeing that's in line with what Professor Stone is talking about is in Texas. Governor Greg Abbott in May signed a 6-week abortion ban, but in order to uphold it, they are basically deputizing citizens instead of legislators. So what this means is that private citizens can sue abortion clinics, providers, and anyone who helps someone procure an abortion if they believe that the abortion was procured after 6 weeks. So this means that an Uber driver who took somebody to a clinic could be sued for helping somebody get an abortion. They were talking about how, in an open letter, they were talking about how the barista at Starbucks, if they overhear you talking about your pregnancy and an abortion, they could file suit against you. And the suing individual would get $10,000 per illegal abortion upon success. So this is something that we are seeing right now, where private individuals are being deputized to regulate women's bodies and women's choices, and it's endangering women's health care.
And we should add, Barbara, that there was a lawsuit filed in federal court yesterday, thankfully, by Nancy Northup, who's a friend of FFRF. We've had her on our Free Thought Matters show and radio and so on. They're suing to stop that, but in Texas, very troublesome that it will go before the Fifth Circuit. So it's very scary and alarming. We're so grateful to you for joining us, Barbara, and all of your reportage for us on abortion rights.
Thank you.
So that'll be our show for today. Thanks so much, Barbara, for joining us. And
thank you, Professor Stone, so much for everything you've written and joining us today to clarify what's at stake.
Thank you so much for having me. It was great fun.
So Annie Laurie, before we sign off, why don't you tell us who was the guest on Free Thought Radio this week?
Yeah, this week, tomorrow, we're going to be interviewing one of our favorites, Robert Jones, who's the founder and CEO of PRRI, which does all of that research on religion. And we'll be talking about PRRI's new 2020 census on religious affiliation.
That'll be great. Showing lots of religious decline and the growth of the nuns, which is the non-religious. Well, thank you so much for joining us. Don't forget, you can listen to the radio show as a podcast.
And come back next week, same time, same place, for FFRF's Ask an Atheist.